4, Mr. Vitale previously was here, entered a plea of guilty to the third-degree felony offense of failure to comply with sex registration requirements. The agreement was for a cap of 4 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yeah, Your Honor.
Yes, Judge.
Any additions or corrections?
Nothing on road, Judge.
Nothing mistake.
All right, Mr. Parker, you may proceed.
Your Honor, Mr. Vitale, he's, as far as I understand, he's done a pretty good job reporting for the last 10 years. He's lived around here, and he's also lived in the Houston area. I think the Houston was the last place that he was registered properly. He ended up going to a place called the Wheelhouse. I think that was called the Wheelhouse.
Yes,
in Deer Park area. He tried to register there, but he wasn't actually a resident. He was doing jobs out of there, but he was living in his car. And then when they denied him because of city ordinance, that's why he couldn't live there, city ordinance rules, then he appealed it and it still got denied. And then he applied. He was going back and forth between his sister's house in Beaumont and working there in Houston. And you tried to apply here in Beaumont as well.
That's where I'm registered at Beaumont.
And
So where are you registered right now?
My sisters on Kipton folks in Beaumont.
In Beaumont.
Yes, ma'am.
And that's where you're living and you are properly registered at this
Yes,
time.
ma'am.
And I believe he's had some issues in the past. He had a substance abuse issue. He's done well with that. I think, he's not one that just ignored what he's supposed to do. I think he's tried, which is way more than I can say for a lot of people. And we're asking the court to give him probation, Judge.
Mr. Smith?
Judge, the state's going to argue for 4 years in prison in this case. The nature of the previous aggravated sexual assault of a child, I think the facts were fairly aggravating, and he was given probation initially, wound up getting revoked when he committed a new offense, and was revoked and sent to TDC for a 30-year sentence and then a 20-year sentence. It looks like even the PSI notes that even though the criminal history is limited, the circumstances of the offenses are severe. He was given probation in the past that resulted in revocation, and looks like he does try to justify his actions in the PSI interview.
I may respond.
Hold on. I just wanted to, when did you parole out? How long have you been out?
2015.
2015. And so since 2015, there haven't been any issues with reporting and it looks like, so while you were since you've been on parole, you've also gone to ISF, correct?
Yes, ma'am.
Okay.
That's why I was still in parole. I discharged in 2022.
You did?
Yes, ma'am.
And I would just like to say that, part of his revocation was, as according to him, and I think the probation officer, was substance issues. And I think that's part of the reason why he didn't get any
Yeah, I mean, it was revoked a year after based
Right.
on a possession case. And that, I mean, I don't disagree with Mr. Smith, but the criminal history, I mean, we're talking about 1991, 1993. We've had 11 years of reporting, and the Wheelhouse is somewhere. I understand you're trying to get some help and do some good things, but you understand you can't do that if you can't.
Yes, ma'am.
You have to be able to be somewhere where we know where you are
Yes, ma'am.
and that you're properly registered.
And that's when they went and denied me out there.
Go ahead.
When they denied me out there, I talked to them. And when I came, I said, I'm just going out there and going, register, back in Beaumont. And then I was still trying to, continue, working the program.
Okay.
Drug treatment program.
So, are you clean now?
Yes, ma'am.
Let's just double check that.
Everything changes right here. A surprise drug test isn't routine in every hearing, But when substance abuse becomes part of the discussion, judges can use it to verify what's being claimed. One result could completely reshape the outcome.
This morning, okay? Have a seat in the jury box. I'm going to have you drug tested this morning. All right, we're back on the record in cause number 25 DCCR 1374. Mr. Vitale tested positive for cocaine. So, Mr. Vitale, you've been to ISF twice while you're on parole. So parole's given you two opportunities not to revoke your parole. And you get off parole and here you are with another felony and you're using cocaine again.
You need some help, Mr. Ma'am.
I'm sorry?
I just need help.
That positive cocaine test instantly destroys the credibility the defense spent minutes building. Instead of seeing someone on the right path, the judge now sees repeated chances, repeated treatment, and repeated setbacks, making prison far more likely than probation.
Well, you've gotten the help and you're looking at a cap of 4, and I was well on my way to giving you an opportunity. But there's no way I can do that with your criminal history and the fact that you've been given, because if you hadn't been to ISF, I'd say, okay, maybe I'll send you to ISF. But you've been twice in the last 5 years. All right, at this time, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of failure to comply with sex offender registration requirements. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Park. All right, good luck to you, sir. You can go back with the bailiff. You're Terrence Currington?
Good.
And so, Mr. Currington, you've been here before and in this court because you entered a plea, so you should have known where you were going, right?
Yes.
Okay. All right. Mr. Currington was previously in court in cause number 25 DCCR 1114, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. Yes, Judge.
Any additions or corrections?
Not from the defense. No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, then at the end, the case will actually be dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for up to 10 years. Do you understand? So it's my understanding that you have a THC card through the Texas Compassionate Use Program. Is that correct?
Yes.
Okay, so here's the thing. If you have that card, you can only use what they give you and the amounts that they give you, right? So when you were caught here, you had a whole lot more of stuff that you weren't supposed to have. 2.6 ounces.
That's not good.
They didn't charge you with it.
The next defendant gets the opportunity the previous one lost, but the judge quickly makes one thing clear. Having a medical THC card isn't a free pass. Probation comes with strict conditions, and even legal cannabis can become a probation violation if it's used or stored outside those rules.
They found some.
Inventory of the vehicle revealed a black backpack in the front seat containing 2 clear plastic bags of suspected marijuana totaling 2.605 ounces. That's not compassionate care stuff, is it? It is. That's how they give it to you in little plastic baggies.
No, that's you see.
She's asking for something.
I'm asking you.
Is that
What? Here's the thing. I'm sorry.
Using the bag, plastic bag.
Is that how they give it to you? Okay.
You just put it in
Why would you do that?
for the smell.
For the smell?
Yes.
To block the smell?
Right.
Well, if you've got a card, then why are you trying to block the smell?
But I just don't want to be right now. Smell like.
Well, how about don't keep it in your car at all?
That too.
That too.
Yes.
So here's the thing. Having that card doesn't mean you just get to do whatever you want and be high and drive a vehicle. You shouldn't have it in your vehicle. You should use it for the purposes and the amounts and the times that they prescribe you to use it. If you're not doing that, then it's going to be a violation of your probation. So part of your probation order is that you cannot have it in a car ever. It is to be at your house, probably needs to be locked up depending on who else you live with, and it is to be used how it's supposed to be used. If there's any issue with that, then it's going to be a violation of your probation, whether you have the card or not. You understand? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to their desk when they're ready to go over your paperwork. You've had 5 felony probations revoked. Then you're here now on 4 more theft cases. So if you want to be there for your kids, then you got to figure out something other than stealing. All right. Are you Rebecca Rideau?
Yes, ma'am.
And Ms. Rideau was previously in court, entered pleas of guilty in cause numbers 23-0928, 23-2106, 23-2107, and 24-1925. All of those were theft of property with previous convictions. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
The defense state has judge.
And there was no agreement. This was just open to the court. Is that correct?
Yes, sir. I believe so. Your Honor, I didn't represent her at the stage where she entered the plea.
Okay.
Understanding it comes from
They were open. And are there any additions or corrections to the pre-sentence report?
None from different. Not from the state yet.
In addition to reviewing that, the state has filed a couple of things. One is a motion for me to run any sentences consecutively, which means obviously stacked on top of each other. And I think I could do that in, I think 2106 and 2107, maybe not, but the other ones I can. Is that, are they different dates?
They're all good.
Are they?
They're
Hold on, I'm looking. Yeah, they're different dates.
Let me make sure. I think all 4 of them.
They are. All right, so asking me to stack any sentences, and then he has filed a sentencing memorandum as well, in addition to a motion for me to deny discretionary jail credit. So, Mr. Kimler, if you would like, you may proceed.
Yeah, I'll just hope that that seems to be ever like this as far as his harshness of the statement attempting to exert in this defendant. And I don't know that it stands out from the few of other cases before this court to deserve such treatment, but it is what it is. I would just observe, first of all, regarding the state's posture on consecutive sentences to denial of discretionary jail credit. There's certainly, the defense certainly has criminal history, but it's not to such an extent or degree in the circumstances the individual cases are such to the extreme degree that it warrants accumulation, and certainly the denial of her jail credit is something that was problematic. I don't know exactly which jail credit the state is attempting to deny her, but obviously if she's been in pretrial detention on these cases, it seemed that she would be entitled to that jail credit without much controversy. Grounds the state would be attempting to deny that. But of course, we would argue that she should be received credit as every other defendant before this court has for the jail time credit that they've done pursuant to these cases. I would note that the pre-sentence report indicates that she does have mental health history dating back to her time in the military, where she was discharged. She had a general discharge, and there was notations there as far as the pre-sentence report that was really involved some health issues. I believe I believe her to be mentally competent. Now, I, of course, wasn't her attorney when she entered the plea, but I would assume she was mentally competent then as well. Although, as I said, she does have mental health history. I think that plays into her present situation with the theft cases that she has. You will note in the pre-sentence report where it's indicated that she was unable to afford the mental health treatment and the pharmacological remedies that are provided through prescriptions, and that she was self-medicating and then turned to theft in an attempt to maintain funds necessary to self-medicate. She indicates in the report that her memory indeed was impaired on 3 of these offenses, and she doesn't seem to remember those. She doesn't attempt to minimize or mitigate her conduct in that regard, where she does, in fact, indicate that she accepts responsibility fully for her actions. But I think that that's indicative of, again, the circumstances surrounding these offenses that, of course, I guess it seems everyone in front of the court these days is finding mental health issues as something that mitigates their criminal conduct. But I do think that in this case, it is well documented, going back again to her military history, that she has suffered from mental health issues. I think probation is an option with the court. Obviously, these are state jails, and court can put her on probation. And I know that the pre-sentence report, you can look at that just to indicate, doesn't really indicate that they're, while they're not recommending probation for Ms. Rio, they don't rule it out.
Well, let's not talk about probation.
Okay.
Yeah.
All right. I'm sorry, but there is.
Well, it is an option, but that's not realistic on what's going to happen today.
They were mentioning that she'd be assessed with a specialized mental health caseload.
I understand that.
So just to note that is in the report.
Thank you.
If the court isn't inclined to consider probation for Ms. Rio, then certainly I think that while she's serving whatever sentence the court gives her, she'd have the opportunity to try to reflect on her actions and perhaps reassess those, where she is with this. And as far as addressing her mental health issues when she gets out, that she'll be able to do that and maintain a law-abiding lifestyle. She has maintained employment, I think, 3 years at City of Owens, if you will. Is that right, Maria? She has maintained gainful employment with the house when her mental health is stabilized, and I would anticipate she would be able to do that in the future if she does have a proper mental health regimen. That would be argument for probation, obviously, that the court's not inclined to do that. So we would ask for a sentence, certainly, that would be concurrent, and that she would be given her jail credit to do something along the lines of 12 months. Straight jail.
Thank you.
You want to address the court?
Right. I just want to say that I do apologize to the court, and I apologize to mom. And I be dealing with some things like news help, but I just want to get a chance to get home and take care of my kids. I miss graduation, I miss prom, my whole senior year. I got a 5-year-old in kindergarten, and my mama got to take care of. I'm just tired. And I want the opportunity to get my life together. I'm tired of this. I'm tired of this. I miss my daughter's graduation. She spoke at Westbrook graduation. I was not there. I'm tired. My baby asked me why I'm the only mom. I'm not at mom's and muffins. That is embarrassing for my kid. I want to go for my kid. That's what a chance to do for me. Mama, thank you. I want to be
Sure. So, Ms. Rideau, I understand that you're asking for a chance at probation, but you've had chances at probation, and you've been given these opportunities in the past for any kind of help and treatment and all of those things, and all of those probations were revoked. And you've had 5 felony probations revoked, 2 at one time, 3 at the other time. So I understand that they were kind of clumped together, but still, After those, all for thefts, you're here for, there was a robbery that you got some time for in 21. And then you're here now on 4 more theft cases. And so, I mean, it's unfortunate and it's sad for your family, but no one put you here but yourself. Mr.
Judge,
Coleman, I know what you're.
yeah, you've essentially hit the things that I want to hit. That in addition to what I put in my sentencing memo, I won't belabor that, Judge. The only thing I would add is she says she's tired of this. I tell you who else is tired of this. It's our local store owners and business owners who are tired. People just walking in and taking what they want from them. She stole from a sporting goods store, from J.C. Penney, from another a clothing store on a couple of occasions. They're tired of it too, Judge. Same little song, just different defendant. I apologize. Give me another chance. I've got all these issues. In fact, yeah, I go one step further than the same old song. It's the greatest hits, Judge. It's what you hear time and time again. And I'm sure she said it back in 2011 when she got probation. In 2014 when she got probation. In 2017, just I apologize. Give you another chance. Got these issues. Judge, if ever there's a case to consider denying her the discretionary jail created under the Code of Criminal Procedure, this is a case.
And it's my understanding with regard to that,
I
but
know it's kind of it's just a bit. Well, I don't say it's problematic, but
I can't give the max and do that.
that's my understanding.
That's your understanding.
Yes, that's it in a nutshell, Judge. And I just say this is a case of that to be considered, and I also say this is the appropriate case accumulator for her sentence, Judge. She needs, in my opinion, some stronger medicine than what she's received in the past in order to impress upon her the fact that she needs to stop engaging in this kind of engagement. Thanks. That's all.
Document.
I would just argue from the standpoint of equal protection as far as the other defendants.
Well, so here's,
What
speak up so she can hear.
I would argue from the standpoint of equal protection laws, Your Honor, what distinguishes her from the other defendants that have been before this court and are similarly situated with similar criminal histories?
Well, here's where
I'm
okay.
sorry.
here's where I am on.
Listen carefully to the judge here. She's balancing accountability with future consequences. While she stops short of imposing the harshest possible sentence today, she's making one thing crystal clear. If the defendant returns on another theft case, the court's patience will almost certainly be gone.
This, I don't disagree with Mr. Coleman. I appreciate that he's gone out and tried to figure out some stronger things to do on some of these cases where we are stuck with state jail felonies. I've been very frustrated with that in the past. I don't know that this is the one to start with either necessarily, but it's not going to be out of the realm of possibility, depending on someone's criminal history, what their prior sentences were. And I don't fully disagree that this isn't one of them. I'm not going to do that this time, but I do appreciate the thought that went into this and don't necessarily disagree that there's going to be a time that this might happen, including to you if you continue to do what you've been doing for your whole life. Because if you're back in here after today on a theft, I can assure you that Mr. Coleman will remind me what he asked me to do that I didn't do. And I will on that. Do you understand? So if you want to be there for your kids, then you got to figure out something other than stealing. I'm going to find in all of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 23, DCCR 0928, find you guilty of the state jail felony of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2106, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2107, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 24, DCCR 1925, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in.
The final ruling is in. All 4 sentences will run concurrently, meaning they'll be served at the same time instead of back-to-back. It's a significant break for the defendant, but the judge leaves one unmistakable warning. Next time, the outcome could be far more severe.
Custody that the law gives you the right to receive. These cases, I am going to run them concurrently, which means together at the same time. Part of the reason I did the 24 months is because I'm going to see that when you come back, that this is the max on a state jail felony you can get. So next time, whoever's here, if it's me or someone else, is going to see that you have progressively gotten worse, your sentences have gotten worse, and when someone like Mr. Coleman files something asking that these run consecutive or that we deny credit, that's likely to happen. I'm handing you in all 4 of your cases the trial court certifications. These show that these were not agreements, and so you have not waived your right to appeal. You can talk to Mr. Kimler about that. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Kimler. Good luck to you, ma'am. You can go back with the bailiff. Thank you for